Hi, I'm Kevin Michalowski, editor of Concealed Carry Magazine, here to answer some of your questions about the difference between the Castle Doctrine and Stand Your Ground laws. We've been starting to get a few questions here at Concealed Carry Magazine about Stand Your Ground and the Castle Doctrine, and I want to go over a little bit about what makes them different and what gives you your rights under those laws. Now remember, Castle Doctrine laws are not found in every state, and every state that has a Castle Doctrine law has a different Castle Doctrine law. So once again, I will tell you, get out there and study the laws in your state. I am just giving you general information about Castle Doctrine and Stand Your Ground. This is not legal advice. We'll start with the Castle Doctrine laws because everyone wants to feel safe in their own home. And everyone pretty much feels the same way. Somebody comes into my home, I'm taking care of business. Well, that's pretty much what the Castle Doctrine laws allow you to do. In general terms, the Castle Doctrine takes away the element of intent. What the Castle Doctrine laws say is that if someone comes into your home while you're inside, that you can assume, and the court must assume, that their intent was to do you harm. And that's very important. Those laws say the court must assume that their intent was to do you harm. That means you have the right to defend yourself with any level of force up to and including deadly force. One of the first cases here in Wisconsin of the Castle Doctrine law involved a young man who broke into the porch of a home. The homeowner came down, found the man in the porch, shot him and killed him. And you might think, that's okay. That's the way the Castle Doctrine law is supposed to work. But there were extenuating circumstances in that situation which caused people to question the Castle Doctrine law. In that case, the young man was 20 years old. He was running from an underage drinking party next door. And in order to escape from the police at the underage drinking party, he kicked in the door of a porch, went inside someone's home, and the homeowner heard that noise, came downstairs, found an intruder in his house, and shot and killed that intruder. The homeowner was protected by the Castle Doctrine, as he should have been. People argued that a 20-year-old boy, they called him a boy, he's not, he's an adult, he was over 18, that this 20-year-old boy didn't deserve to die because he was running away from an underage drinking ticket. I counter that argument. That 20-year-old boy, that young man, should have known better than to kick in the door of a total stranger's house and go inside. That's something you just do not do. Now again, in that case, the Castle Doctrine removed the element of intent. The homeowner did not have to establish the intent. The Castle Doctrine states that when someone comes into your house while you're there, you can assume, and the court must assume, that their intent was to do you harm. The area where the Castle Doctrine will not protect you is if you come home from a night out and you see someone in your house, you can't draw your concealed pistol and head inside your house to confront that person. In that case, if you come home, you see someone inside your house, no one else is in there, and you know the house to be empty, there's not a family member or anyone else in there, you can't go into that house pursuing the intruder. You should then call 911, stand back and be a good witness, and wait to see what happens. Okay, now we'll shift over to the Stand Your Ground laws. A lot of people think that Stand Your Ground laws and Castle Doctrine are almost interchangeable, and they are not. In the states that have Stand Your Ground laws, the Stand Your Ground law simply means that you don't have to retreat from any area where you have the right to be. If you're in an area where you have the right to be and you find yourself in a confrontation, you still have to determine and be able to articulate your aggressor's intent. And you have to be able to articulate the aggressor's intent. Did the aggressor have the means and the opportunity to commit an act which would cause death or great bodily harm to you or another person or persons? In that situation, Stand Your Ground laws mean you don't have to back down. You don't have to retreat. And when I say have to retreat, there are some states where you have a requirement to retreat before you use deadly force. You have to find out if your state is one of those. And if you have the requirement to retreat in your state, you have to be able to prove that you have done everything in your power to avoid that situation before you employ deadly force. The Stand Your Ground law simply removes that requirement of retreat. You don't have to retreat. All the other elements in the requirements to use deadly force must still be present. Your opponent must have a weapon, he must have intent, and he must have a delivery system. The only thing that a Stand Your Ground law changes is that it removes from you the requirement to retreat. And I would argue that if there is safe retreat available, you utilize that safe retreat. Remember, the best fight is one you're not in. Just because you're protected by a stand your ground law doesn't mean you should engage in a deadly force incident. Remember, when you pull your gun and shoot the bad guy dead, that doesn't mean the situation is over. When you use deadly force, your problems have just begun from a legal and emotional standpoint. I'm Kevin Michalowski, editor of Concealed Carry Magazine, and this has been Into the Fray.